determined by the borrowers that the requirement of passing a reasoned order must be read into. They relied on jar developers where it was said that this must be made by a reasoned order. And then they say, of course, you must give reasons. But of course, it's not like I'm asking you to write a judgment. You're not a judge, but you must give reasons broadly. That is okay. I mean, nobody's saying that you're a judge who has to give a reasoned judgment. Well, to the same effect is the more general case, which has been cited now in all your lordship's cases, including this one, Dharampal Satyapal. That is 2015. In the compilation, it is the previous one, 2015, 8 SCC 519. Para 27. It's a frequently cited judgment.
Yes.
It brings to speed all the case law on this. Now, one of the other facets is, what does it matter even if you heard me, the result would be the same. Lordship is dealt with long ago. Now, even if you hear me, the result would be the same. Why should I waste time hearing you? See, 42. Important question posed by Mr. Sarabji as to whether open to the authority which has to take a decision to dispense with the requirement of the principle of natural justice on the ground that affording the opportunity will make no difference. To put it otherwise, can the authority dispense with the requirement of issuing notice by itself, deciding that no prejudice will be caused to the person against whom the action is contemplated? Answer has to be in the negative. It is not permissible for the authority to jump over the compliance of natural justice on the ground that even if hearing had been provided would have served no useful purpose. Because Gandhiji's old dilemma, means and ends. He always insisted on the means with us. Ends are okay, but means, that's important. Then 43, they again affirm that principle of prejudice. One is that no difference would happen. Second is prejudice. Both are affirmed. We still need natural justice. And then it goes on, to deal from para 41 onwards to 44. And ultimately, they give primacy to natural justice. Now, my next point relates to a reminder for 2 minutes only of the very remarkable dates in this case, which your lordship noted with me last time. Lordship notes will bear it out. There are very few dates. May I just remind you, lordship, those 6-7 dates? Correctly typed? Well, I had oralized it, lordship, and yes. I've got a 1-pager just to put it on this here. Give to other side also. Same person. Yes. Well, these are all in Kannada, but of course we have Kannada experts here. Well, 1992 is the notification. 98, it is denotified. And was right through, not a single file.
No. So what happened after denotification?
This what is coming up. It's coming up. I'm just saying one general thing. Not a single file came to him in any capacity as Chief Minister, Deputy Chief Minister, or the relevant minister. He was never holding that portfolio. Never. Survey is denotified through the government notification. Then 3 is 2004. Records show the change of land ownership from Devaraju. First was Ninga. Ninga's son is Devaraju. And finally comes Mallikarjuna Swami. Now, Ninga and Devaraju, which is for 20-30 years earlier, have no connection, no relation with the Chief Minister. None. In 2004, the sale deed comes to my brother-in-law, whose name is Mallikarjuna Swami. That is 2004. So the entire sequence of denotification, purchase in auction, denotification, acquisition, etc. is all before it was anything to do with me at all, with my family also. Much later in 2004, this brother-in-law buys it from sale deed. Then 2005, conversion is done. Gift deed comes to my wife in 2010, his sister. And then in 2014, an application is filed to allot an alternative area because no compensation, because the admittedly that whole thing has been used or otherwise encroached upon, etc., or dealt with. So they say, look, this whole thing will to reverse the whole thing and to give pristine land again. Therefore, alternative is asked. It is done for a large number of people, and then 2020 and 2022, the sale deed. This is one of the broad picture. Today, you are having in 24 some kind of a outburst as if some massive scam has happened, which is not open to anything. This is just a perspective. I repeat, with great respect and humility, and this is important, I should have said so in the beginning. And I'll be making it as the first point in my rejoinder when I file it. I am always dealing with these facts on and off because I don't want my lords to feel in conscience that I'm suppressing or avoiding anything. But I'm very clear that these two counters we have received yesterday in day, full of facts, as if your lordship is hearing a criminal trial. Now, my respectful and humble submission is that I am not required to answer a single fact. Don't misunderstand me. When I give a lordship these dates, they are landmark dates. I am A, not required to, B, I am not obliged to, C, I am not going to reply to these facts. Why? Because the issue is the sanction.
Yes.
Now, I am not required to do that because the validity or otherwise of the sanction depends on the argument of the applicant, the argument of, if I may call myself the non-applicant or the objector, and the governor. There is no list in a counter affidavit in the High Court that your lordship will give a civil or a criminal decree on these facts. Your lordship will pass a criminal law order. Your lordship will find a guilty. Your lordship will give a civil decree. This is not the job. Question is what you are today, this is important, what you are today arguing in these two objections full of facts is not what the governor did. Is not what the governor did. The governor passed a simple 4-page order. Today, you are not a super governor to justify that governor's order by giving all these facts.
No, it is on the basis of their requisition sanction is granted.
Correct.
So they are defending.
No, of course they will defend. I understand. But I'm just saying my necessity to rebut individual facts, to say that, look, this is criminal, this is not criminal, this is culpable, this is not culpable, doesn't arise. Because your lordship has no reasoned order. Yes. Suppose the governor had passed a reasoned order. Lordship has dealt with many cases like this. Sanction is not a new thing. Governors pass reasoned orders. Then possibly I'd have to say, look, this is where the governor has said 2 + 2 = 5. And he's wrong. Because on that date, I did not exist or something I could say. But there is no need for that because there is nothing to, I'm not here to answer a list on a civil or a criminal side with the private people, complainants. That's the perspective I'm urging my lords to keep in mind. So whatever I say, I say it really more from the purpose of disabusing and creating the fact that your lordship is, I'm not keeping away anything, but not because I'm obliged to or required to in this proceeding to answer anything. The facts, otherwise, just to end on the facts, show the overriding point that public servant whom you are seeking to prosper. Has your lordship ever seen a public servant? And now, of course, we have repealed that section also in the PC Act, where for this long period when this person was born, this brother-in-law, on which year? Which year the brother-in-law by? 2004 till now. I have never dealt with the file. I'm not the portfolio minister. I have never passed any order, and the decisions taken of denotification otherwise have been passed for a number of people, not for me alone. And yet after 20 years, 24 is 20 years after 2004, this is happening. So that has to be kept in perspective.
He also says this, that he is not affiliated any manner that the commission of discharge no official duty. He says so.
No. Now, the other aspect is, this 218, your lordship's old 197.
Yes.
Broadly. Now, my short point, this is more or less what I said earlier, because nothing major has come for me to deal with in the counter. But broadly, the points are threefold, if I may ABC tell your lordships. The granting is under 218 also at page 47. Your lordship noticed that last time, yes. Page 47 specifically. Now, this section has to have some specification of the ingredients of the offense, what offense, how offense, which way the ingredient of that section is fulfilled.
That's
before you
quasi
get-
sanction.
That's right. So, Malaz, I'm just saying that specification is nowhere there. I am not concerned. I'm not saying that you had to grant. You didn't have to grant. It's possible to say, I don't have to grant now, I'll grant later. That's not what he's saying. He has granted. My question to myself is, he has granted on what? Well, the ingredient, I say 420. So you have to say that I am granting for 420 because in this way I came to him, I represented to him or misrepresented, I got movement of property, etc., something. There is nothing. It's established that 218, etc., must make out the attempt to make out at least the ingredients of the offense. That is missing. That's separate, Malus, and independently as fatal as the submissions I have made, Malus, regarding 17A.
Yes.
Now, Malus, I'll just end in a minute. Give me. Well, may I say that since I've argued most of the matter, let me just note the paras. It's a
Of-
more intellectual.
judgments?
No, so I've done with the matter, Malaz, as far. I'm just, Malaz, since it's more of an intellectual thing, I'm not arguing it. But Malaz, this submission that he's not bound at all may be a larger legal issue. which your
Not bound
lordship
of
may-
what?
By the cabinet.
That will.
That let me oralize it for
So
lordship.
that's a
I'm
prima
not,
facie, we will see.
Yeah,
Well,
yeah.
yes.
but well, only why I'm saying it, I'll tell you. Well, there is a judgment of MP establishment which suggests otherwise. As simple as that. My learned friends rely on that. Now, whereas Nabam Rabia, which is a constitution bench,
Para 156.
is the conclusion.
Yes.
But it cites, well, as the conclusion says you can only act in your own discretion in 3 cases. It lists them. I read you last time, 156. 155? 155.
155. right,
Now,
yes.
admittedly,
Uh.
this doesn't fall on those 3 on the text. Clearly. Now, MP is also 5 judges. Nabam is also 5 judges.
Yes.
Nabam is later.
Later.
But Nabam, with the conclusion in 155, saying only these 3 categories in which we don't fall, cites fellows MP in 7, 8 paras, just note the paras, because it's a very long judgment,
Yes.
140 to 142,
Yes.
you don't say what these paras are, I didn't say, stop in between the sentence. I'm sorry, but just cut out that para. It is cited in the following paras, Manoj. 116, 118, 128-29, 315, 317, 2 more paragraphs, 326 and 337, and lastly 362. Now, a later judgment citing the earlier one and was coming clearly to a conclusion in 155, which categorizes 3 things where we don't fall. At least the High Court Balas should prefer to follow the later one, but that at the moment I don't argue. I'm just pointing out that not that Balas, it's a frivolous argument. I'm not that Balas.
The 5 judges saying of this court.
Yes, yes.
The due to-
And Balas, your lordships have, of course, this is obvious, Balas, I don't need to, a 5-judge full bench of your lordships, Karnataka High Court, said that when there is some apparent variance between an earlier 5 judges and a later 5
So
judges,
later will prevail.
and you will follow that. That's your lordship citation of 1979.
No, that's
SCC online. Many of them are there. Whereas I would therefore say that, of course, reserving fully my right to not only file, but to argue a rejoinder fully. This case is a fit one, whereas this sanction cannot be there. What they do in future, what they find, what is applied, etc. This sanction must go. This sanction actually can and should go on the admission of some of the complainants themselves. But whereas that apart, I'm not dependent on their admission. Your lordship is entitled to say on both counts. It's not that your lordship can say because of those reasons it doesn't stand, but I otherwise go into it, otherwise also find this. This sanction is, well, it must go for the separate reason that there is no reason. None at all. Those balas are my submission, very deeply obliged. I reserve all those rights
All right,
because
yes.
I'm sure some, in the light of my arguments, your lordship rarely has that I finish my argument. then a new
No, no,
counter
you
will
can-
come,
You
a
can
new
explain-
angle will come, and the new angle I can't do this, therefore
No,
the
that's
lordship
all
got
right.
there in mind.
Yes, anyone today or
Well, I am ready, my lord, but if the Solicitor General, my lord, it would be appropriate if lord
is,
hear
is
him.
there?
I have a
Yeah,
suggestion.
my lord, I'm here, my lord. Am I
I have a
audible?
suggestion which on one of the
One-
rare occasions, Mr. Mehta may agree with, may agree, I don't know, Manas. It may be a rare day, but he may agree. Well, Saturday, I'm told is a working Saturday for.
Yes. It is.
This Saturday.
Mutual benefit.
Yes,
yes,
this
yes,
Saturday
yes,
is a-
Perhaps you did
Saturday.
not know, Mr. Mehta, so your agreement will be in our mutual benefit.
No, I don't go by the benefits, Dr. Singhvi, but Saturday is fine
Yeah.
with me.
Saturday is fine.
Saturday is fine.
Subject to Mr. Maninder Singh is also appearing, my lord, my learned friend.
Where is?
Somebody can start. Manas, let it
Yes,
go on.
yes.
I may be
Finish.
permitted to start. Please.
It won't finish anyway, so then.
No, Mr. Singh, would
fine.
it be
Let us
possible?
see, Saturday is fine, no
Yes,
difference.
yes, so Mr. General's convenience is important.
Can't hear.
So that is 20.
First.
Now, whoever wants to submit, then you will have to resubmit on when the rejoinder is filed if needed.
Please, correct.
But what if you want to submit, you can submit.
Yes,
Please,
please.
31st. We are talking of this Saturday, Manas, 31st.
Yes, this
31st, yes, my lord.
Who are you? Intervener? Intervening as what? Petition? For what? Your fundamental right, who has taken away? So first, what is your right that is taken away? Hmm.
Just can I interrupt for 30
No, no,
seconds?
this is
There's
not.
an old saying, Malas, sometimes, Malas, your friend can be your worst enemy. Please don't think that I have set up anybody, Malas. I'm not
No, no,
interested.
no, I-
The problem is, Malas, anybody comes and argues, people blame me.
No, I don't think you,
No, that
I don't think
happens.
you need a friend to be set up.
No, Malas, a friend is worse than an enemy sometimes. That has happened many times in litigation.
Where does this road lead to? The caterpillar would say, you don't know where you want to go, it would be taking there.
We'll see, we'll hear. Not in this, it is, no, not,
Lord, if lordships are to start hearing us from Saturday,
wait, sir,
no.
damage will be caused to the state.
No, I would assist the
That-
court on behalf of
No,
the
no, sir.
governor. Thereafter, Mr. Maninder Singh is there.
We are not hearing a PIL here. It's an order of the governor that is called in question by the person against whom the order is passed.
On par with the petition of the respondent. Because this constitutional significance is better.
All right, we'll see. Wait. No, your application is, you have filed it. We'll consider it. Yes.
If Saturday, my lords, if the Solicitor General wants to start,
Huh.
it would be appropriate, my lord, that he
Yes,
finishes
sir.
it and thereafter I continue. Yes,
Is
but
there?
if
So
he
Mr.
has
Maninder Singh is
he'll
also
argue.
there.
We are ready.
Let it be
Whoever-
10:30. I will complete and Mr. Singh can start.
Yes,
Please.
Today,
No, my lord, Saturday, my lord, if you allow.
Saturday, all right.
deeply obliged, deeply obliged.
10:30, my lord, can it be at 10:30?
We'll start it with 10:30 and conclude it. Yes.
Please.
And all of your, the rejoinder later on.
Well, Legion will have to be later because they will be having a lot of things, but
I
one
know.
day more I'll finish it off. One day more.
That's all right. Yes.
So
I'll
Saturday,
take account of everything and make my note also accordingly.
Yes, yes. Let
As
the
single
respondents,
note. Yes.
respondents finish.
Yes, yes.
Hope all of you will finish on Saturday.
as much as possible, we'll finish Saturday.
All right.
Allocate time for us, so we know how much time we have.
It's all right.
Each of you.
No, it's all right, my lord.
Each
We'll,
of us will not allocate.
All right. I don't think each of you are saying something contrary to each other.
No,
Then-
absolutely not.
All right.
But two broad issues, my lord, we will address that, subject to what there are and Solicitor.
No, then Solicitor General will start
We'll
first.
start.
And all of you
We'll
will
follow.
next follow. Yes. Then we'll do it on Saturday.
Yes.
Yes. Heard, that I will do. That we will do.
Grateful to you, lord.
Heard the learned senior counsel Abhishek Manu Singhvi, who has completed his submissions for the present and would reserve his right of rejoinder submissions once the submissions are concluded by the respondents. The learned Solicitor General submits that
Saturday.
the matter would be taken up on 31st. He would complete his submissions on the said date. Records may be required, sir.
I will keep, my lord, my record present.
Yes,
which
sir.
can be-
Would complete his submissions on Saturday. List the matter on Saturday at 10:30 AM. Interim order granted on 19/8/2024 shall continue till the next date of hearing. Yes. ನಿಮ್ ನೋಡೋಣ ಆಮೇಲೆ. Wait, yes.
One of the record, including the other application, status of the other applications also, your office.
What applications?
You have produced 4 other complaints which are pending.
No, every record will be produced.
Not only passing of this order, Manoj.
Oh, you mean from the office of the governor?
Yes, yes, they had said,
4
Manoj,
applications also. what
I
is
have
the
named them,
status
I have
of
named those applications.
No, but I'm unable to see who
That
is
is-
requesting.
That is for the perusal of the court. They will do it.
The
yes.
perusal of the court, Manoj.
No, it's my contention, so Lordship can peruse it, of
Kindly
course.
Will answer.
My
But it is
contention
a
writing.
state has nothing to do with this, my lord.
Governor
Accused,
has everything to do with this,
potential
Manoj.
accused and the
is
governor
the one who
will.
has passed the order, sir.
The complaint that have been referred to by my learned friend Singh are under 19. They are not under 17.
No, I asked the senior counsel that they are all after investigation
Exactly.
and wanting sanction to file a charge sheet.
So there's-
No, the problem is 218 is also referred, that's the reason.
Lord,
And he would say 218 is referred for the reason that
Paper.
IPC offences are there in that.
Right.
There
In
cannot
fact,
be-
is which?
That should be submission.
Lord, much emphasis, my lord, was laid on pendency of sanction applications, my lord, in connection to 4 legislators, my lord. Now, my lord, pursuant to the dictums laid down by the Honorable Apex Court, my lord, what precluded, my lord, my learned friend, my lord, the Chief Minister of the State of Karnataka, my lord, to, my lord, pass directions to approach this Honorable Court seeking necessary directions to the Honorable Governor, my lord. No, my lord, because the governor was termed as a friendly governor. Now, my lord, with all liberty, I would call the Chief Minister as a friendly Chief Minister.
To those complaints.
Chief Minister,
Certainly.
my lord, unlike the governor.
Certainly. Now, my lord,
Friendly to the constitution.
my lord, they have quoted pendency, my lord, since so many years. My lord, nothing
No,
precluded
let's
them.
see what is pending and what is not pending. The office of the governor would place the files. We'll answer. The contention is taken, we'll answer it.
Please.
That's all right. That doesn't mean we pay.
No, my lord,
you
now
want
this
to play
vote
a
is
friend-
acting on your
No,
head.
no, it doesn't mean you want to play a friendly match here, right?
Certainly not, my lord.